Namaste dosto. Welcome back to my YouTube channel called IVD Manufacturing. So today we'll be discussing on a topic called Chapter 5, which is import of medical devices. But we'll be talking mainly a specific topic, which is the grant of import license on Form MD15, whereas you'll be filing the application in Form MD14. So if you are applying for the import license for the medical devices in India, then under Rule 36 of MDR 2017, the CLA, after reviewing your application, will decide whether to grant or reject this license. So in this video, let's break down the process, the timelines and conditions for the approval. So what are the timeline and decision? So the moment you file the MD14, the CDSCO, the CLA is going to review a document or the inspection report and may grant the license in Form MD15 or rejects the applications. So usually the CDSCO will take 9 months from the date of the application, and in case of rejection, the reason must be recorded in writing and will be circulated by the CDSCO to the particular applicant. Right? So my friends, if you are not happy with the CDSCO decision, you may go against the CDSCO. When I say may go against it, it means you can file or you can appeal in case of rejections. So no need to worry my friends, if your application is rejected, then you can appeal to the central government within 45 days. The government will review and pass an order within 90 days of appeal. So 45 plus 90 you can consider, right? However, your import license may get on a fast track by the CDSCO with following free fill certificate. If your device, the medical device which you are going to import from the overseas manufacturing has already had the free sale certificate from the trusted regulatory authority like Australia, the Canada, the Japan, the European countries or the USA, then you can get the import license without clinical investigation in India. So this is very interesting my friends, right? But what about the medical devices coming from the other country? So for the devices imported from the other country, the class C and D, the license is granted only after clinical investigation in India proves that it's complied with the safety and effectiveness. Whereas for the class A and B, the license may be granted if safety and performance is proven through a published data, clinical administration in the country of origin, or free sale certificate from the country of origin. So it is based on the criticality of the medical device or the classification, right? What about the import for the investigational devices, right? So for the investigational medical devices or new in vitro diagnostic devices, you must first get the prior permission in Form MD27 and Form MD29. So MD27 is for the medical devices, 29 for the in vitro diagnostic devices. Without this permission, no import license will be issued, my friends. Be very careful, right? So just to recap, the CLA is going to grant the license from MD15 within 9 months. You can put the appeal to the central government and within 45 days, right? Your license can become very fast track if the device is coming from the following country like US, EU, Canada, Japan, Australia, since the no clinical trial is needed. Class C and D classification of medical devices require the trials, whereas A and B doesn't require. Investigation devices needs prior permission in Form MD27 and MD29. So if this video helped you understand the licensing processes, don't forget to like, share and subscribe for more MDR 2017 updates. Till then, take care, bye bye.